So I've talked about the issue of, registering a trade name or a mark that is a brand for your business, especially in the age of the internet, where everybody just looks everything up. It's kind of helpful to kind of distinguish your business from others and to kind of tag on the name that your business is with to attach it to your business and have that be something that doesn't become easily confused with other brands too easily. But so what do you do if you find out that, something that you want to, either a name of a business or some sort of phrase that you want to use exclusively for business purposes is somebody else just either thinks of it or they took it from something you wrote or whatever it is, then what do you do? How do you respond? What you want to do is you want to write to them, basically a demand letter, like a cease and desist letter, basically. And you explain to them that you've registered this, and you give them the USPTO registration information, and you tell them how long it's been in use for, and that you had it in use since this duration of time, and this and that. Or if you want to license it to them, you can talk about that to them too. You can talk about how they can use it, but they have to pay you a certain amount, and you have to they have to come to a certain agreement with you on how to use it and in what context they can and whatever have you. So if you want to give them permission to go ahead and do that, you can bring that up in the letter too. So basically, that's the way you want to handle that, is just kind of be upfront about how what you've gone about, how you've made the efforts to protect the brand, the trademark or the name that you've made the efforts to secure, and that in this context, and that they can't use it. If they live in another country and they want to use it again, like I said, you can license it to them or whatever have you. And that's another thing to think about. Just because you register something in the United States as a trademark doesn't mean that translates in every other country. It translates in some country. There's something called the Madrid Convention that a lot of countries signed on to, which means that something that is protected under trademark laws in the United States is also simultaneously effective in a number of other countries. I don't remember every country that it is, but I do know that some countries are not signatory to that. For example, I don't think that Canada was. It wasn't last time I checked, which was a few years ago. So they might be now. So in that case, you want to register with them too. In particular, English-speaking countries that are not part of that convention are important, because it's very easy for the brand to become confused with them, and for your brand to become confused with a trademark that's registered in another country that's not part of this sort of international trademark agreement sort of thing. I think with China, I don't want to be specific. I'm not sure whether they're registered to it or not, but even if they are, I think that the convention with them is that you always want to register with them locally. You always want to, because anything from outside their country doesn't mean anything to them. It's not going to mean anything there. So with them, you always want to make sure to hire local counsel in that country and in their language, and register something there if you want it to have effect there. So I know with that country, you really want to make the effort, because anything international will just have absolutely no effect at all. So those are some things to think about in terms of, if you have any questions, feel free to ask, and I'll tell you or find out for you. Thank you.